Federal Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is essential to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The society seeks both to promote an awareness of these principles and to further their application through its activities. We've got two very special guests today, the first of which is Judge William H. Pryor, Jr., who serves on the U.S. Court of Appeals for the 11th Circuit. From 2013 to 2018, he served on the U.S. Sentencing Commission, and from 2017 to 2018, he served as acting chair. Judge Pryor teaches as a visiting professor at the University of Alabama School of Law. He also taught as an adjunct professor at the Cumberland School of Law at Stanford University. Judge Pryor served as Attorney General of Alabama from 1997 to 2004. When he first took office, he was the youngest Attorney General in the nation. In his re-election, he received the highest percentage of votes of any statewide candidate. Judge Pryor graduated magna cum laude from Tulane Law School, where he finished first in the common law curriculum and was editor-in-chief of the Tulane Law Review. He served as a law clerk for Judge John Minor Wisdom of the U.S. Court of Appeals for the 5th Circuit. Judge Pryor is a member of the American Law Institute and an advisor for the restatement of the Law Third Conflict of Laws. He is a co-author with Brian Garner, Justices Neil Gorsuch and Brett Kavanaugh, and several other justices of the treatise titled Law and Judicial Supremacy. He has been published in many law reviews, including the Yale Law Journal, Columbia Law Review, Virginia Law Review, Harvard Journal of Law and Public Policy, Yale Law and Policy Review, and the Tulane Law Review. He has published op-eds in the Wall Street Journal, the New York Times, National Review, and USA Today. He has debated at the National Lawyers Convention of the Federalist Society and at the Oxford Union in the United Kingdom. And he is listed among several widely admired judicial writers in Brian Garner's The Red Book, a manual on legal style, and has been recognized for exemplary legal writing in the Greenback Almanac and Reader. Judge Pryor is a member of the Tulane Law School Hall of Fame and has received the Jurist of the Year Award from the Texas Review of Law and Politics and the St. Thomas More Award from the Atlanta chapter of the St. Thomas More Society. Our second speaker today is Professor Josh Blackman, who is an associate professor of law at the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of 3 books: Unprecedented, The Constitutional Challenge to Obamacare; Unraveled, Obamacare, Religious Liberty and Executive Power; and an Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Professor Blackman has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He is an adjunct scholar at the Cato Institute, and Professor Blackman is also the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and blogs at joshblackman.com.
You should all play.
I've got questions for you about that later, about how that works. Professor Blackman is the author of over 4 dozen law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. Without further ado, please welcome our speakers. Judge Pryor.
Thank you. And I should add a note to Judge Pryor's biography. Am I right that you're the only person to hold commissions from 3 U.S. presidents? Am I right about that?
Well, I have 3 commissions.
Right.
From 2 presidents.
From 2 presidents, right? So the only one from both.
I have a recess appointment from George W. Bush.
Uh-huh.
A good behavior commission from George W. Bush, and then a commission from President Obama to serve on the Sentencing Commission. I was nominated by President Trump to serve as chair of the commission, but things are so dysfunctional in Washington and they've taken so long to come up with a slate of potential nominees that I've told the White House that I'm done with my tenure on the Sentencing Commission. I'm scheduled to become the chief of the circuit in June, and so I don't guess I'll get a Trump commission.
Oh, news to me. Well, it's a pleasure to be here. You are very fortunate to have Judge Pryor on your faculty in any capacity. He is one of the leading thinkers in the country, and he's right in your backyard. So you're very lucky. If you can take his class, I would recommend you do so. This is my first time in Tuscaloosa. Thank you so much for having me. I'll have some barbecue right after this, but I'm very happy to be here. The topic today is judicial supremacy. And this is a topic that most law students simply don't think about. Most law students come to law school as 1Ls, and all they see are courts, judges making all these decisions, both wise and foolish, that affect all aspects of our lives. But let me disabuse you of that notion. The courts are not the only branch of government that we have that can fix problems. The legislative branch can write new laws and repeal old laws. The executive branch also has authority to perhaps enforce or maybe not enforce some laws that may be deemed to be unconstitutional. Things only get to the courts when the other two branches decline to act for one reason or another. And the mere fact the other branches decline to act does not mean that the courts have to act. All right? So the courts are not the beginning end of all questions. They're not the alpha and the omega of life. And I want you to begin with that simple premise. Okay. The second premise is that you may have learned things about judicial review that aren't accurate. Now I see a couple of Collin professors here, so I won't ask you to raise hands. But I'm sure many of you were taught, maybe not in this school, that Marbury versus Madison, right, that famous case from 1L, that John Marshall invented judicial review. I learned that when I was younger. And it's simply false. It's not true. The concept of judicial review existed before John Marshall. The Supreme Court had exercised it before Marshall was even appointed. State courts had exercised this authority. English courts had exercised this authority. That is, when you had a written law, a statute, that was inconsistent with a higher law called a constitution, that the court would then have the duty to follow the higher law and disregard the lower law. So judicial review wasn't new. But you may have learned something else about the Supreme Court, what might be called judicial supremacy. The idea that Marshall in Marbury said that the Supreme Court has the final word on what the Constitution means. And that also isn't true. If you read Marbury carefully, and by the way, Judge Pryor wrote an essay, very, very short, less than 10 pages, on various myths about Marbury. I want you to read his essay after this, but if you read his essay, I think he makes his point extremely clearly. Marshall explains that all the branches, all the departments of government play a role in interpreting the Constitution. And this may sound obvious, but it should be simple, right? If you are a police officer, right, and you're deciding, do I pull this person over? You're thinking in the back of your mind, do I have probable cause to make this search, right? If you are a member of a county commissioner and you're looking to perhaps regulate someone's property, you're thinking, would I have to provide compensation for this taking? If you're in the city hall office and you're deciding whether to grant a permit for a parade, you think, if I deny this permit, am I violating their rights of free speech? Right? If you're in a zoning authority and maybe you deny a church a building permit, you think, am I violating their rights of free exercise? Right? On a daily basis, government officials at every level, from county commissioner to mayor to a police officer on the side of the road, are thinking about the Constitution. Right? All of the branches, all the departments of government have to think about the Constitution. Indeed, the Constitution commands that very result. Go to page 30 of your Constitution. I know you all took one from the back of the room. But we go to what's called the Oaths Clause, right? It's the Article 6 of the Constitution. It says, the senators and representatives, the members of the state legislatures, and all the executive and judicial officers of the United States and the several states. The president has his own oath. It's mentioned in Article 2, so he's not included in this category. But this language covers appointed positions, elected positions at both the state and federal level. And what do they have to do? They shall be bound by oath or affirmation to support this Constitution, right? They're bound by the Constitution, right? They're not necessarily bound by the federal laws, and that's an important point we can talk about in a few minutes, but they're bound by the Constitution. So the same duty, the same judicial duty that John Marshall followed when he decided that the Judiciary Act was unlawful is the same duty that the cop has, the same duty that a county commissioner has, the same duty that a mayor has. We all have this duty. If any of you work for the government at any level, you will take an oath to the Constitution. You will. So, you raise your hand, whatever, it's a nice thing, but you take an oath to the Constitution. Oh, see, I was wondering how long until he perks up. It didn't take him 5 minutes. It's okay. We're old friends, maybe at least for now. Yes, right hand. Thank you, Judge. But we all take this oath to the Constitution. Now, why does this matter? If we all take an oath to the Constitution, why are some people's opinions in the Constitution more important than others? In other words, if a police officer says, you know what, I think this search was valid, I pull this person over, I think it complies with the Fourth Amendment. And then the judge says, no, you're wrong. You did not have probable cause to make this search. Right? Why is it that we say, you know what, the judge is right, the cop is wrong, and the cop must abide by that ruling? Right? Let's say that the person pulled over sues for damages and says it was an unlawful search. And the court says, you know what, you're right, there was not probable cause. And we assume that the officer was in the wrong here, completely inappropriate search. But the cop says it was fine, right? So why is it that the courts, even a district court judge, gets to have the final say, so to speak, over the executive branch? And this poses a much more difficult question, right? It's not just about the Supreme Court having the final say, it's that we've delegated to the judiciary this authority to sort of resolve disputes. That is, when people in the other branches disagree about what the Constitution means, for better or worse, I think for better, our polity has given the courts the power to adjudicate that. And of course we have the state courts, and they are fully equipped to resolve constitutional disputes. Don't forget about state courts. They are valid officers. They take the same oath. And federal district courts. And if people don't like that, they go to the Circuit Court of Appeals. And if people don't like that answer, they can go up to the U.S. Supreme Court. And the Supreme Court's last, right? It doesn't make them right necessarily. I think they're wrong quite a bit, but they get the last say in these issues. And we've accepted this. But I think the fact that they're last has led to this impression that they are supreme. Now, they are a Supreme Court, no doubt. But we should be recognizing a simple fact. The Supreme Court doesn't actually declare what the supreme law of the land is. Right? If you read the Supremacy Clause, which is the very next, on the exact same page as the Oath Clause, it says the Constitution, and the laws of the United States, and the treaties are the supreme law of the land. Right? They are the supreme law of the land. It doesn't mention who decides what the Constitution means. I think that's a power that's most naturally given to the courts, but that wasn't a given. We could have had a different structure, maybe a different norm could have developed, but that's not precisely what happened. But in a series of decisions in the 20th century, the Supreme Court has articulated what is now known as judicial supremacy. This wasn't from Marbury, this wasn't from Dred Scott, it wasn't even from this century. It was from more 20th century cases, where they basically said that our interpretation of the Constitution is the supreme law of the land. That is, when the Supreme Court makes a decision without qualification, that is the new law. Now, why does that make a difference? We are all obligated to follow the supreme law of the land. If you're a government official, you have to follow it. When the Supreme Court says our decision is the supreme law of the land, it's like we've had a quiet amendment process, just no one told anyone, right? It's like we have a new 28th Amendment, a 29th Amendment, a 30th Amendment, right? You know, we've had a Constitution for many years with few amendments, but we've had a lot of them because the Supreme Court changes it every couple of terms or so. But when you have these decisions that the Supreme Court announces supreme law of the land, it has an effect, okay? You've learned in Civ Pro as 1Ls that when I sue you, right, we have a suit, A versus B. Any judgment that results from that case is binding on who? The two of us, A and B. Is C over there bound by our judgment? No, he wasn't a party to the case. What happens when the judgment isn't just between A and B? when the Supreme Court actually says we're reading the Constitution to mean something completely different, that judgment has effects beyond A and B. And this is not a nationwide injunction or a non-party injunction. It's a completely separate matter. But when the court asserts the authority to bind parties not before the court by virtue of reading the Constitution in this broad fashion, I think we get into some problems, right? Because it literally means the Supreme Court has changed the supreme law of the land. And we know the only way to change that is an amendment. What happens if a different majority comes along a few years later and reverses it? Let's say the Citizens United decision, 10 years old today. Let's say we had a Justice Merrick Garland instead of a Justice Gorsuch. And you have a Justice Goodwin Liu instead of a Justice Kavanaugh. Could have happened. Could have happened. And what if they reverse Citizens United? Do we say that it was supreme law of the land for a couple of years, had a good run, but now it's not anymore? It's happened before. There was a decision called the legal tender cases. This was a case about whether paper money can be required to be accepted as currency. Believe it or not, paper money was controversial. There was a 4-3 decision one year that says you cannot make people accept paper money. And the very next year, we had 2 new appointees to the court. It went 5-4 the other way. That the exact same facts, the exact same legal issues flipped depending who was in the court. So this notion of judicial supremacy is problematic precisely because the Supreme Court, as a body, changes its opinion from time to time. And I think we should be hesitant to ascribe to the court the power to define the Constitution, because that takes the power ultimately away from those who are most responsible for changing it, which is the people, through the amendment process. By giving the court this authority, we are divesting the people of this power. Okay. So now let me move to sort of an abstract discussion to one that is perhaps a little bit closer to home, and this is one that Judge Pryor is quite familiar with, right? Let's say you're a state Supreme Court judge. I don't know, your name's Roy Moore, right? And I don't know, let's say you get the idea somewhere in your head to install a ginormous monument to the Ten Commandments in the lobby of the state Supreme Court. Well, it could happen, right? And then let's say a district court judge enters an order, an injunction, saying that that establishment of a monument violates the Establishment Clause. Now, you could disagree with it. I think it was probably wrong in light of some other case law, but we can leave it there for a minute, right? Am I advocating that the judge can simply disregard a binding injunction? No, I'm not. I think a judge, like anyone else, can have their opinion on what the First Amendment means, and maybe Moore's right, maybe Moore's wrong. It's not relevant for today's discussion. But I think at least in our system, for better or worse, the courts have been given this sort of, I don't want to say final say, but this sort of authoritative resolution to avoid disputes, to avoid what you might call chaos, where every man becomes a law unto himself. Okay, so I think on that one, we can probably all agree. But now let me give you a different example. I'm going to modify the facts slightly to make it simpler. But this one involves same-sex marriage litigation. We had a very complicated situation right here in our state of Alabama. All right, what happened? A federal district lawsuit was filed in Mobile. And initially, the suit involved a couple probate judges, but eventually a class was certified to encompass all the probate judges statewide. The probate judges are the ones who actually had the licenses for marriage. Okay. So at one point, you have a lawsuit filed in Alabama federal court. But then a conservative group, the Alabama Policy Institute, API, sues in the state Supreme Court in the original jurisdiction. Don't ask me how that works. I don't know. But in Alabama, you can do this. Maybe he can explain it to me, right? But in Alabama, you can seek basically almost a declaration in the original jurisdiction of the court. And Judge Pryor will tell me why I'm completely wrong. And the Alabama Supreme Court issued an order, which I think they have the authority to do, saying judges continue to issue licenses consistent with Alabama law, which means do not issue licenses to same-sex couples. The judge then in Mobile says, oh, no, that's wrong. that in light of Windsor and other decisions, it would violate the 14th Amendment to enforce this Alabama law. Therefore, I'm telling the probate judges in the state to halt their enforcement of the Alabama marriage law. So this creates a conflict, right? The federal judge then in Mobile, a federal district court judge, issued an order to the probate judges saying you have to issue these licenses to gay couples. The state Supreme Court, sitting in Montgomery, says, order, you must continue to enforce Alabama law. Now let's look at this situation carefully, right? Was the federal district court judge in Mobile required to listen to the state Supreme Court? I don't think so. She had her own oath, she had her own commission, she had her own office, she had her own courthouse. She can then interpret the Constitution as she sees fit. And she made her decision, which was consistent with what Obergefell held some time later. Was the Alabama Supreme Court required to follow the lead of the judge in Mobile, the federal judge in Mobile? I think the answer is also no. State Supreme Courts are not bound by the rulings of federal district court judges. Now, he might get mad, but I don't think state Supreme Court judges are bound by circuit rulings also. I think they have their own commissions, they have their own authority, they have their own oaths, and I don't think they're required to follow the rulings. They can lead to different directions. I think we have one institution in our country that can resolve these disputes, and that's the U.S. Supreme Court. But what happens when no one files for certiorari? And that dispute's never resolved. That's where we are today. Obergefell's old. My goodness, what's almost 5 years? Oh my God, it's been 5 years. Obergefell's almost 5 years old now, right? But to this day, I think you have dueling injunctions if you're a probate judge in Alabama. The Alabama Supreme Court dismissed the case, and they did it in sort of a weird fashion that I don't fully understand, but I don't think they dissolved the injunction. And generally, a court injunction that's not dissolved remains in effect in perpetuity. I mean, it's sort of a weird, maybe it fades out on its own, but I think the Alabama Supreme Court injunction remains in place. And I think the federal judge in Mobile, her permanent injunction is sure as heck in place. So what are you going to do if you're a federal judge, you're a probate judge, and you have these dueling injunctions, right? Federal court says do A, and state court says do B. Well, we know the answer because no one's following the state court, right? They're all basically ignoring it. I think the reason why is because the federal judge will probably put sanctions on you pretty quick if you violate it, and the state court wants nothing to do with this case. So as a matter of realpolitik, the federal court injunction actually trumps. And that's more or less what happens, even in the absence of a Supreme Court decision. But you can imagine that you have this conflict set up, and there's one judge says, I will follow my state Supreme Court, not who federal judge. And if we go down that road, the Supreme Court would have to intervene very quickly. Now, the hypothetical I'm giving you is not made up. This happened during the massive resistance following Brown, right? We all learned about Brown versus the Board of Education, which said, in the context of public education, the doctrine of separate but equal has no place, right? We all know that opinion. What people don't always get is Brown didn't actually issue an order. After Brown was decided, the case, the court said, let's have another round of arguments. Let's argue this again. And we had a case called Brown 2. Brown number 2, decided about a year later. And Brown 2 was decided, how do we implement this decision? How do we implement this decision? And ultimately the court said, we don't really know, but we'll let the lower courts take a stab at it, and the lower courts should integrate with all deliberate speed. Right? That was the phrase they used, all deliberate speed. What does that mean? Well, you think it means at a somewhat rapid pace. Well, that wouldn't happen. Shortly after Brown 2 was decided, we have the massive resistance. And these groups sprung up, like the White Citizens Council, throughout the South. I'm sure they had some in this state as well. But the locus, the core of these cases arose actually in Little Rock, Arkansas. And what happened in Little Rock? In Little Rock, a federal judge issued an injunction to integrate Central High School. But then a state court judge in Pulaski County issued a contrary injunction. The state judge said, hey, we have a law in the books saying schools remain segregated. I'm ordering you, the school board of Little Rock High School, to continue enforcing the Arkansas segregation law. So you had this conflict, right? Federal court said one, state court said the other. But in that year, what did the governor do, Orville Faubus? He followed the state court injunction. Now, he didn't need an injunction. He was going to do what he was going to do anyway. So I don't want to even pretend this was some sort of law-abiding activity. But at least in theory, he can go to court and say, Your Honor, we're following this injunction. And they were very careful to make that argument. And at that point, the Supreme Court resolved and said, no, none of this state court stuff, you're wrong, the federal court's right. But you needed that resolution, okay? Now let's go back to Alabama for one more minute. When Judge, is it Grenade, how do you say her name? When Judge Grenade down in Mobile entered a final order, she cited a very unlikely source. She actually cited, in her opinion, Roy Moore. And Judge Grenade quoted from Roy Moore and said, the reason why I need to issue a final injunction is to create clarity where there's none. She basically said, I'm going to read you her opinion. She said, the Alabama Supreme Court's failure to set aside its prior mandamus, a prior injunction, demonstrates the need for a permanent injunction in this case. A Burgerfell by itself does not provide uncertainty. That case only concerned marriage laws from Ohio, Kentucky, Tennessee, and Michigan. She said, the court finds as long as the Alabama laws remain in the books, there's still a live controversy, and this district court must give relief. So for better or worse, the district court judge in Alabama, Mobile recognized that when you have these dueling injunctions, you have to have some sort of resolution. In this case, we had a final order. In theory, that could have been appealed to the circuit court, 11th Circuit here, or it could have been appealed to the Supreme Court. As far as I know, no appeal was filed. They said, all right, we're throwing in the hat, we're done. But this episode illustrates at once why judicial supremacy doesn't actually work, right? The mere fact that courts issue an order doesn't resolve the disputes. People have to want to actually follow them, right? When you have the massive resistance in Arkansas, after the Supreme Court ordered schools to integrate, what did the schools do? They shut down. They just closed the schools for a couple of years. Or they basically start spending tax dollars on voucher private schools that could have segregation, right? So at the most basic level, for a court to issue an injunction, people to follow it, there has to be at least enough of a desire among people to follow it. If there's not, we go back to the massive resistance. So ultimately, this concept of judicial supremacy doesn't really exist. But as a practical matter, when courts issue injunctions, at least in our society today, people still follow court orders. That can change tomorrow. I think that'd be a very bad thing. But I think it's at least how things work today. Okay, I think I've said enough. Judge Pryor's been patiently waiting, and I welcome to have a discussion afterwards. Thank you all so much.
So I agree with a lot of what Josh has said today. I'm not sure that he's got the Alabama marriage litigation actually right. And that's because these were not identical lawsuits. You're right, the Alabama policy seems to be one unusual action in the Supreme Court of Alabama. Do you have a copy of that?
Yeah.
Were all the probate judges named defendants?
Give me 1 second. Let me look it up. And I'm getting some really bad feedback. Okay. Okay. Let me check.
I think it was the wives that were.
I see. So I know this though, that the couples who wanted to have the same-sex couples who wanted marriage licenses were certainly not parties to the Alabama litigation. The Alabama Policy Institute was. It's true too that the Supreme Court of Alabama dismissed the case before them. I don't think that means that there remains an injunction. I don't think you can have an injunction in an action that is no longer pending. And the bottom line is this. I think the simple answer for why the probate judges followed Judge Grenade's injunction is because anyone, if they were somehow countermanded by somebody else, Judge Grenade, to the extent that a probate judge wanted to follow that different direction from another state official, could have joined that state official as a defendant and issued an order to show cause why that person should not be held in contempt. A lot of that kind of stuff happened in the civil rights era. School officials would be named as defendants. Other school officials, particularly elected officials, would try to interfere with desegregation decrees. Federal district courts, in the exercise of their equitable powers, could join those state officials who sought to frustrate the desegregation orders as defendants and issued show cause orders against them, and could potentially hold them in contempt of court. I think the lawyers who probably handled that litigation understood all of that, and that's why there's really not the kind of stalemate that Josh describes. What?
They sued Judge Doe's 1 through 63, so that they lumped them all in, which is strange. Yeah.
63 or 67.
They named 4, and they said,
Okay.
yeah, yeah.
We've done it with those for 1 through 63. Yeah. But vis-a-vis the probate judge and the couples who wanted marriage licenses, those couples were not parties to that case.
Mm-mm.
Their rights had been adjudicated by the federal court, and the state Supreme Court ultimately dismissed their action in the wake of the Obergefell decision. I think the important part of the lesson, if you really wanted a good example of why judicial supremacy is not a thing, I agree with your reading of Marbury. I think John Marshall was very clear in Marbury that in making the case for judicial review, he accepts the fact that the Constitution binds the other branches of government, and that the other branches of government have the authority to interpret the Constitution. But then he interprets some provisions of the Constitution, including, for example, those that pertain to the bills of attainder and those that pertain to treason, and says, it's pretty clear that this Constitution is directed to courts too, and that it's a rule of law for both courts as well as for other departments of government. So his argument was not an argument for judicial supremacy. His argument was one for constitutional supremacy. He recognized that the judiciary had an equal role to play. And do you have an idea why the feedback is still high?
Let me, hold on.
He recognized that the judiciary had a role to play in interpreting the Constitution.
I'll just, can we just unplug your mic? That might make it easier.
Yeah.
I'll just unplug yours while you're talking.
Yeah. Don't pull the plug on me.
Yeah.
Try his first, because I think mine was okay.
Yeah, I don't know what's up with yours, Ginger Pryor.
Will they hear me?
Yeah.
This one was not being a problem.
Yeah. Yeah, you can hear it now.
Yeah.
Good. So, he was making the case for judicial review. He was making the case for the authority of the court to interpret the Constitution, to decide a conflict between the statute and the Constitution, and saying, we have this power too. The other branches clearly do. We have this power too. That's the argument he makes. It's not an argument, though, for judicial supremacy. And no one really ever understood it as an argument for judicial supremacy for a very long time. Marbury ends up being distorted in history much later. Guess how many times the John Marshall Court cited Marbury as a precedent for judicial review? Anyone? Zero. Yeah, 0 is the answer. Never. And there are other instances of judicial review. I thought at the time that I wrote that essay, there's one mistake in that essay. I said the next time the court declares a federal law unconstitutional is in Dred Scott, and the Taney Court did not cite Marbury. It's true, the Taney Court did not cite Marbury and Dred Scott. What I was wrong about, a lot of scholars, I relied on some scholarship that was wrong. A lot of scholars have said that's the next time. It's not actually right. I understand now that there were some congressional acts, for example, that dealt with title to submerged lands on the Mobile River that the Supreme Court of the United States declared unconstitutional under the equal footing doctrine before the Dred Scott decision. There are some other exercises of judicial review in between Marbury and Dred Scott, but those decisions too do not cite Marbury for the proposition of judicial review. It does not get cited again by the Supreme Court until in the very late 1800s in the famous income tax case, Pollitt versus Farmers Loan and Trust. And by then, Marbury has taken on this kind of mythic proportion as not just this moment when the Supreme Court established judicial review. I agree with Professor Plattman.
It's Josh is fine.
Professor Plattman. That was already a very well understood and well established judicial duty that we had inherited from English common law. That was something judges clearly understood, and even in the American experience had been exercised by state courts and federal courts. So Marbury's not particularly special for that reason, and it wasn't controversial at the time that it was decided for that reason. But it takes on this mythic proportions later on when what was then regarded as the conservative wing of the American Bar Association, which was very much a laissez-faire kind of establishment, opponent of economic regulation, wanted the federal courts to strike down federal and other laws that regulated property rights and contract rights. And Marbury is championed as this great precedent for the power of federal courts. And then in the early 20th century, progressive historians who believe in legislative supremacy and are opponents of judicial review, or opponents of the Lochner Court and the striking down or the interference by federal courts with economic regulation, that they, I should not ever use the term striking down.
I didn't want to correct you.
No,
He caught himself quick enough.
Courts don't strike down.
They don't. They do not.
They only decide cases for controversies and declare that the law that governs those parties is whatever it is. But they don't strike down laws. There's a great article about that by a guy named Jonathan Mitchell called The Writ of Erasure Fallacy that really explains that idea. But those progressive historians in the early 20th century, they really made John Marshall out to be this Machiavellian character who was playing, political games with Marbury versus Madison to establish a precedent for judicial review and to establish the power of the Supreme Court in this battle with Thomas Jefferson. And it's mythology. It's not really what was happening there. What Marshall ended up doing was avoiding a confrontation with the Jeffersonians by dismissing the action for lack of jurisdiction. And there was really no controversy about the judgment where he declared Section 13 of the Judiciary Act of 1789 as applied in that case as unconstitutional, and it exercised the power of judicial review, which Thomas Jefferson accepted and thought, in fact, that he was familiar with the practice of Virginia judges of exercising judicial review, and had advanced that as a good reason for a federal Bill of Rights. So this is kind of where we get this mythology from. It's much later that Marbury becomes kind of a weapon that sides are wielding in their debates about the proper role of the federal judiciary. So if you want a good illustration, though, why at the end of the day the courts are not the final arbiters, go back to a much earlier controversy. So Congress, along the lines of the views of Alexander Hamilton, established the Bank of the United
United States. There was a lot of controversy about whether that was a constitutional exercise of congressional power or not. Jeffersonians thought it was not. And Jackson thought it was not. But the Hamiltonians and the Federalists had carried the day, and the federal courts had declared that was constitutional. But at the end of the day, who had the last word? There was legislation to reauthorize the Bank of the United States. It came to the desk of Andrew Jackson, and what did he do? He vetoed the legislation. He vetoed it on one ground. It was unconstitutional. If the courts have the final word on what the Constitution means, then how is it that President Jackson ended up having the final word in that circumstance? He had the final word because his veto meant that the law did not take effect, and it was on a constitutional ground. He had the final word. Courts have the final word when they decide cases or controversies between parties, but that does not mean that their decisions are binding on everyone and for all times. And the point that Josh made about if it were not that way, then how is it that the Supreme Court can overrule itself? The Supreme Court overrules itself when it misinterprets the Constitution. Plessy was wrong. Lots of decisions of the Supreme Court were wrong. And the Supreme Court later rules that it had been wrong. Does that mean the law changed? No, it means that the court was always wrong about what the law was. It does not have to change the Constitution. The Constitution doesn't change. The court's interpretation of the Constitution is what changes.
Very good. Thank you. And if you haven't read much about the bank controversy, it's an excellent example of what you might call departmentalism, right? So imagine this: you're President Washington, and you're given this proposal. Do I sign into law this Bank of the United States? So you say, let me ask my cabinet, see what they think, right? So on the one hand, you ask Thomas Jefferson, who's your Secretary of State. You say, Thomas, I want you to write me an opinion. And Thomas Jefferson asks as a friend, James Madison, for some help with that. And then you have your other cabinet member, Alexander Hamilton, the Treasury Secretary. Right, so Hamilton says, yes, it's valid. Right? The word necessary and proper in the Constitution gives a lot of leeway to Congress to enact certain types of useful laws to execute federal powers. And then Jefferson and Madison say, no, we have to construe the language strictly, right? What's absolutely necessary. George Washington says, well, I'll go with Hamilton, right? You don't need the Supreme Court to resolve disputes. Imagine that. People can actually resolve on their own. And John Marshall didn't decide McCulloch till years after they all left office. And by the way, John Marshall cribbed from Hamilton quite a bit with Marbury, with McCulloch, right? A lot of Marshall's best work was basically plagiarizing Hamilton, but it's okay. We all know where it came from. All right, I got 12:50, so maybe we can stop here and take some questions, and maybe we can go back and forth as well. So thank you so much, and some questions. Yes?
So I actually have a question. So Judge Pryor talked about courts deciding cases and controversies between those particular parties that are litigating. And President Blackwood talked about how when the Supreme Court essentially, with all these decisions that it issues, is essentially amending the Constitution without going through the proper channels to amend the Constitution. So I think what I'm trying to distinguish is, where does the court doing its job of interpretation end, and you kind of see them getting into more of the amendment territory of the court?
I was going to say, in response to Josh, that I don't think the court really ever steps outside its role. If you buy the notion of judicial supremacy, the court's not supreme. It's not the ultimate interpreter of the Constitution. So insofar as the court says it is, well, that's just not true. The court doesn't say that so much anymore. They certainly did in the Warren era, but you don't see the court saying that so much. Now, in what way are the decisions of the Supreme Court binding on non-parties? Well, they're not so much binding on non-parties. What they are is they're binding on courts. So insofar as the same kinds of cases or controversies come before courts in the future, as between different parties, we know that as a matter of precedent, as a matter of stare decisis, that inferior courts are bound by the decisions of the Supreme Court unless and until the Supreme Court decides to overrule its decisions. So in that sense, they are binding, but there's nothing inconsistent with how the Constitution operates in that circumstance. The other branches are still free to disagree. President Lincoln disagreed with Dred Scott. He protests Dred Scott in other circumstances because he wanted the court to overrule itself, to overrule Dred Scott. He issued a patent to a black inventor. He did things to test Dred Scott as a precedent. Totally legitimate. But inferior courts, to the extent that parties bringing cases or controversies to the courts, are going to be bound by whatever the latest decision of the Supreme Court is.
I'll play devil's advocate slightly. Why are lower court judges bound by Supreme Court decisions? They take an oath to the Constitution, not to the Supreme Court.
They do take an oath to the Constitution, but they take an oath to the Constitution that establishes one Supreme Court. And they take an oath to a Constitution that structurally understands that the judicial power of the United States has been vested in one Supreme Court, and that at least for the purposes of the exercise of judicial power, that means that that court is entitled to establish precedents that are binding on the judicial branch. There's nothing inconsistent about that. They do take an oath to the Constitution, but that Constitution also recognizes that the Supreme Court is, as you said earlier, supreme.
All right. I got more to say. Let's get to student questions. Another question.
What was more were you going to say?
Well, one case I think the Supreme Court comes close to talking about supremacy is Bernie versus Flores. That was a case involving RFRA, the Religious Freedom Restoration Act. As people are moving, so I'll be brief. Congress enacted a statute to provide greater protection for exercise of religion. The Supreme Court said, no, you can't do that. Only we get to interpret the First Amendment, not you. And that comes awfully close. Wherever that line is, it comes close to that line.
Well,
Please.
that's not really what they did. What the Supreme Court said was, as between the city of Bernie and the church that brought the lawsuit, the Congress of the United States may have misinterpreted the 14th Amendment, but they granted Congress has the power to enforce the provisions of the 14th Amendment. So they recognized that Congress has the power to interpret the 14th Amendment. Now, it may be that the Supreme Court would conclude that in a case or controversy that comes before it, that Congress had misinterpreted the 14th Amendment, and that in fact Congress did not have the power to enact the law that was purportedly governing their dispute. But that's just like any other case, Josh.
You give the court way too much credit, Judge. Yes.
In Justice Kennedy not saying that the Supreme Court has just as much power as Congress, and that Congress can't penetrate on the Supreme Court's power to interpret the Constitution?
I'll let him answer. I read the case a little differently, but I'll let the judge answer.
I mean, I think that's right. But when the case comes before it, and the question is, well, is the Religious Freedom Restoration Act valid to govern the dispute between these parties? The court has to do what? What the court did in Marbury, decide whether that law conflicts with the Constitution. It's a conflict between inferior and superior law.
So where's the case? Have we had a case yet where they've said that Congress was allowed to do it? Have we had any other follow-up RFRA cases?
Sure. In
State.
fact, yeah, well, what the court said in City of Bernie itself was that Congress could pass prophylactic legislation that goes beyond even what the Constitution itself forbids if they have a record of demonstrated state abuses of those constitutional rights. And they used as an example provisions of the Voting Rights Act of 1965. They later declare in
Shelby.
no, well, I was going to say the Nevada case.
Oh, Hibbs.
That the Family Medical Leave Act was a constitutional exercise of congressional power under the 14th Amendment. So
We're almost out of time. We'll take this one offline. Are there any other questions? I do want to make sure we get anyone else. Going once, twice. Thank you all for your attention.